And it's a perfect bridge to where we are honored to go now. Because my friend Richard Suskin, when we talked about this, he said, I think I might be able to get the incoming Master of the Rolls to come and share some time and thoughts with us. And he said to me, because he is one of the most thoughtful people I know in thinking about how we move forward to get the best of this new world. And so I am deeply grateful that he has made time to be with us today. And I'm going to turn it back over to my friend Richard Suskin to give a proper introduction to our honored guest. Richard.
Thank you very much, David. And thank you all three of you for such a fitting and moving tribute to Ralph. I only had the opportunity to meet him on that one occasion, and it was an online meeting. Even across the wires, I could sense what a wonderful man he was. And it was a real pleasure to have worked with him, if only in that one time. But yes, David, thank you for giving me the enviable task of introducing Sir Geoffrey Vos, who's currently Chancellor of the High Court of England and Wales, and soon to be the Master of the Rolls, which is the head of civil justice in England and Wales. I've got the great good fortune of working regularly with Sir Geoffrey. We plot and plan in relation to technologies, and our ideas are very much aligned. Colin Passmore of Simmons Simmons said it well earlier, and I'm not sure the extent to which Geoffrey's aware of this, but he said there's a great sense of enthusiasm within the profession for Geoffrey taking on the role, and it is a time when considerable reforms needed, not least in relation to technology. Geoffrey, I'm not sure when you actually joined the meeting, because I know you had other commitments. I spoke, as you will know, about the more distant future. We had a wonderful panel from experienced practitioners who told us about what it's like at the live end of all of this, conducting hearings. In the broadest of terms, I think one of the clear conclusions were these hearings work very well for oral argument, but far less well for cross-examination. But I focus very much on video hearings. I think Harold, you may have heard Harold say he would like to hear from the Master of the Rolls on the extent to which, if hearings go virtual, that international dispute resolution, if I understood it, he was saying might be drawn more to America. Well, that of course overlaps with our own interest, as we're both members of something called Law UK, where we're very keen that the English legal system continues to be a leading forum for the international resolution of disputes, or the resolution of international disputes. So Geoffrey, I don't want to take up your valuable time. People would rather hear, as David said, about you, rather from you rather than about you. So can I hand over to you to take the reins for this keynote address? Thank you very much.
Well, thank you, Richard. Thank you very much for that kind introduction, and thank you, David, too, for having invited me to speak to you today. It's an honor and a privilege to do so. Let me start by giving you an overview of where I'm going to go in this short talk. England and Wales has always been one of a number of popular jurisdictions for the resolution of international commercial disputes. And for the last 4 years, I have led what we now call the Business and Property Courts in England and Wales at the Rolls Building in London. And that building is probably the biggest commercial dispute resolution courthouse in the world. Pre-COVID-19, between 40 and 50 judges would sit every day to resolve every kind of business dispute in shipping, construction, insolvency, financial services, banking, intellectual property, competition, tax, and much more. And now the same number sit each day, but many, if not most of them, do so remotely. And I know from the very few minutes that I have been able to join before starting to speak to you that you've had much discussion about remote hearings. But in January 2021, as you've heard, I'm going to be moving on to become Master of the Rolls and Head of Civil Justice in England and Wales. Now that's a much broader canvas than commercial dispute resolution. And in preparation for this new role, I've been thinking a lot about civil dispute resolution far more widely than I could have done from a purely commercial standpoint. As everyone listening will know, whatever they tell you, judges and lawyers the world over are instinctively conservative, and perhaps it might even be said slightly resistant to change. Court processes have developed parochially over centuries and are driven by the culture of local societies. All court systems, whether civil or common law, were developed to resolve disputes in their own country. They were not developed to resolve international disputes, let alone those arising from borderless technologies such as the blockchain and smart contracts. And this essentially local foundation for justice systems explains why those that have grown to service international business, such as the business and property courts in England and Wales, the Singapore International Commercial Court, and the courts of the Southern District of New York, all face the same problems when it comes to creating justice systems fit for the 21st century. How do they square the resolution of massive disputes for international conglomerates with local dispute resolution for New Yorkers, Londoners, or Singaporeans? The backdrop to the delivery of justice has also changed beyond recognition, now that almost every individual and business in the developed world, and many in the less developed world, can get whatever they want instantly with a few clicks on their smart devices. And as it seems to me, there are essentially three issues that underlie the creation of the modern dispute resolution system. First, I think the emphasis should be on the resolution rather than the dispute. And secondly, we should not, I think, undertake reform by simply doing digitally what was previously done in an analog way. And thirdly, we should try to approach the whole problem holistically. I will explain in a little more detail the implications of each of these underlying points. But first, let me outline the vision as I see it for the future. Justice must cater for a broad range of disputes. Leaving criminal questions on one side, that range extends from the 60 million small civil issues resolved every year by artificial intelligence on eBay, through millions of family disputes about money and children, via many more millions of administrative disputes between the citizen and the state, to a range of commercially debilitating disputes faced by small and medium-sized enterprises, and ending up with the large, intractable commercial cases between multinational corporations at the far end. And these disputes are dealt with by online platforms, ombudsmen, arbitrators, mediators, and sometimes, but only sometimes, by municipal courts. And it's important to understand the range of cases that is being considered when one looks for appropriate reforms. Otherwise, there is a danger that the highly lawyered tail may wag the self-represented litigant dog. And there is, as I see it, no reason whatever why there should not be a single point of online entry for every dispute, however small or large, whether civil, family, commercial, or administrative. A data set can be created from the outset, and the dispute can then be directed towards the most appropriate resolution mechanism. Secondly, the process should not, I think, be governed by the concept that every case will end up in a traditional courtroom with all the witnesses, parties, lawyers, and a judge gathered together in the same place at the same time, whether that gathering is actual, physically, or remote. Some may, I'm not against traditional court hearings, but when you consider the full gamut of disputes that need resolution, any idée fixe about the end point needs to be carefully managed. And thirdly, mediation, resolution, compromise, settlement interventions, call it what you will, should not be, as they so often are, at a single point on the journey, but they should be an integrated part of the entire system. Parties that have a problem should be led culturally to expect that the process will be about achieving a resolution, rather than about exacerbating or even necessarily always deciding who is right about the dispute that gave rise to the process. Every case can enter a metaphorical online funnel. Resolution interventions will cause many of them to settle, but if they do not settle, the process will be directed at identifying and then resolving the issues that divide the parties. It should not be about formal statements of the competing hostile positions, or pleadings, as lawyers call them. The process should instead itself identify and resolve issues in a logical, progressive, and conciliatory manner. As the online programs are developed within the funnel for an ever wider category of case, some will need in the early stages to leave the online space to be dealt with under the legacy systems. And the development process will take time. But the ultimate objective will be to create a ubiquitous online dispute resolution process that can resolve almost all kinds of issues at a proportionate cost, in a reasonable timescale, and without the stress of unnecessarily confrontational set-piece hearings. Now, of course, there may still be a need for remote or face-to-face hearings or meetings at some stages and in some cases. But these should, I think, be tailored to resolution of specific issues, rather than being allowed to transform themselves into costly and lengthy pitched battles. So how then do we avoid digitizing the existing process? The common law dispute resolution process is one that developed to its present form in the 19th century. But even then, hearings were generally much shorter and more peremptory because there was just so much less paper. Through the 20th century, the process became more complex as document reproduction took hold. And now the volume of data is overwhelming as a result of widely available electronic communications and social media. I make these points because it's easy to think that reform of the dispute resolution process is in some way a betrayal of the history of the common law. In my view, it is quite the reverse. If we do not bring dispute resolution processes up to date, we will drown in data. Even the simplest of issues will take years to resolve. And so far from promoting access to justice and the rule of law, the process itself will depreciate them. It's interesting to note what has been learnt in relation to dispute resolution from the effects of this awful pandemic. In the UK, remote hearings, whether by phone, Skype, Teams, or Zoom, replaced face-to-face hearings in the majority of cases across the civil, family, and administrative system almost overnight in March 2020. Judges, lawyers, witnesses, and parties were quick to realize the advantages, even if there was a little grumbling along the way. And many are now seemingly reluctant to return to face-to-face hearings, even when they are safely available. Remote hearings have gone well. They're not ideal, as I've heard some others say before, for the resolution of every issue, but generally they operate efficiently and save time and expense. But they are not themselves a solution. They simply replicate the old process in a technologically enabled form. And likewise, the digitization of bundles of documents and the court record is necessary and appropriate, but not a solution in itself. In order to create a justice system that can genuinely resolve the wide range of disputes that arise in our society, we need a fresh approach that takes account of existing circumstances. Now, those circumstances bear no relation to those that existed in either the 19th or the 20th centuries. Those circumstances are the ready availability of the internet to all our businesses and citizens, the massive accumulation of data affecting every aspect of our commercial and personal lives, and the availability of smart systems and artificial intelligence that can process that data and assist us in every aspect of our experience. None of these circumstances is going away. Technology will grow rather than recede. Moreover, disputes will themselves become more technological in nature. In financial services alone, there are, we are told, likely to be trillions of smart contracts recorded on the blockchain. And blockchain technology is likely to affect every aspect of consumers' lives. Once it's in regular use by utilities, by land and intellectual property registries, by central bank digital currencies, telecoms, and corporations and industries in every sector. Once you realize the kind of society for which dispute resolution is required in the future, it becomes obvious that it would not be sufficient to put our existing procedures online. Why, for example, would one want an online process that simply required the same old pleadings and formal documents to be drafted and uploaded to the dispute resolution platform, when simple programming can arrive at the issue in an ordinary case far more efficiently? In most cases, the issue is really very simple. Was the car going too fast? Did John lend Mary $500? Did the defendant pay the mortgage installments that were due? The objective in all cases must be to identify the real issue in dispute by the quickest possible route. And that route may vary, but the objective should remain. The part of this analysis that is most contentious with lawyers is the part that suggests that in many cases, traditional oral hearings may not be necessary. But I've already said twice that I accept the need for some hearings, even in a reformed online process. What I think one needs, however, is the streamlining that aims to resolve online as large a percentage of the cases as possible, using a series of targeted interventions. We have experience in the UK of parties to small claims thinking that because they've paid a fee to issue their claim, they're entitled to a hearing by a real judge and implicitly a judgment in their favor. I would prefer them to think of any fee they pay as a fee for the solution of a problem, not for the hearing of a dispute. And this also affects commercial cases, where the ultimate trial becomes a goal in itself, with mediated interventions sidelined and undervalued. So where would an online process leave the lawyers? There's no doubt that many lawyers, whilst acknowledging the sense of what is proposed in this talk, hope that the comfortable dispute resolution process of yesteryear may continue at least until they retire. In my view, lawyers should be more ambitious. Precisely the same parameters that make a new dispute resolution process essential ensure that lawyers and legal advice will thrive in the coming century. The advance of technology, big data, the blockchain, and smart contracts will lead to different, perhaps more complicated personal and business relationships. Lawyers should always concentrate on adding value for their clients. They will be needed more than ever as the complexities of everyday life and commerce increase. There is no need for lawyers to specialize, for example, in drafting repetitive court documentation, when the issues that divide parties can be dispelled and resolved online in half the time and at a quarter of the cost. But there is, and always will be, a need for lawyers to advise their clients on their future commercial decisions, their transactions past and present, and the merits of their dispute, and for them to assist the courts, whether online or not, in resolving them. The issues arising in relation to families and between the individual and the state are hardly likely to become any more straightforward in a technological era. So what then about international arbitration and major commercial disputes? I turn then to the commercial lawyers litigating these massive disputes, either in the commercial courts in the UK, the US, Singapore, or at international arbitration. How can my perspective possibly apply to them? Surely the case with millions of documents, dozens of witnesses, and billions of dollars at stake will always take many weeks or months to resolve in a physical courtroom. Well, my answer to that is maybe. These were the kinds of cases that I was involved in when I was at the bar. However voluminous the documentation, I always found that even the most complex case boiled down to an analysis of a very few documents and perhaps one or two difficult points of law. We see that as cases progress up the appellate ladder. They become more focused and simpler. As appellate judges are fond of saying, it was argued quite differently before us. We only saw that single point. The trick, I think, is to identify the single point or the very few real points, whether evidential or legal, at an early stage. And artificial intelligence and the legal discipline of experienced lawyers can help with this. There is a tendency for lawyers to want to argue every point, good, bad, or indifferent, whether it's from fear of being sued themselves or simply to impress their clients. But this is a tendency that should be resisted and would, I think, be a tactic that would be harder to pursue if the process were put substantially online. So let me attempt to draw a few of the threads together. I do not think that judges and lawyers have a choice about the direction of travel. The only real question is when they get with the program. Our present method of courthouse-based dispute resolution is simply not fit for the present era. It cannot cope with massive data, smart technologies, the blockchain, smart contracts, and the artificial intelligence that epitomizes the world in which we all now live. And I believe that we owe it to the generations that have grown up with technology to use our experience to fashion new online dispute resolution mechanisms that can provide what my generation never had, namely access to justice for all levels of dispute, whether trivial and soluble by Amazon or eBay, or serious and requiring the attention of a state judiciary. It should go without saying that there are three parameters on which we cannot and will not compromise. First, the integrity of the judges and the system itself. Secondly, the imperative that any new approach to justice must command the confidence and respect of our populations. And thirdly, the quality of justice delivered. The new processes will, I think, provide better justice for a new generation which has different expectations. Justice cannot be so expensive and so delayed that it is in truth unattainable. Thank you.
So Richard, I'll just say I see why there's so much excitement in the UK. around Sir Geoffrey Vos's ascension to being master of the rolls. We cannot thank you enough for that really thoughtful and deeply substantive discussion with us of the challenges, but also the opportunities that we face here, prompted, of course, by my friend Richard's brilliant start to our discussion. What we're going to do now is try to engage some other voices, and Sir Geoffrey Vos has very kindly agreed to stay and perhaps engage and answer with some questions. And we're going to start with three people who have a unique perspective on the issues that we've now been discussing and who are struggling with them themselves in their own way, in their own court systems. Each one I'm going to call on in turn, who will say a word about themselves and then ask a question for one or all of us to answer. We won't actually be able to see them because that's the format of the constraint of the webinar we're in, but you'll get to actually hear their voices. So the first person I want to call on is my dear friend and former Harvard Law School classmate. I shouldn't say that. He was my student. He wasn't my classmate, but he was my colleague at Harvard Law School. And now he, like Kathleen, has also gone on to greater glory. This is David Barron, who's a judge on the First Circuit Court of Appeals here in the United States. And Judge Barron, would you unmute yourself and please ask your question?
Thank you, David, and can I be heard? Yes, okay, great. Thank you, David, for inviting me to do this and for putting on this symposium for Ralph Gantz. I mean, among the many great qualities of him was he was also very good as a mentor. And me as a young judge, I know he took me aside and helped me a great deal in acclimating myself to the bench, which is just one of the many great qualities about him. But Sir Vos, I really was struck by how stimulating and thought-provoking your talk was, and it prompted me to think about an issue that we face on our circuit and that I think is endemic to the US justice system, which is that there's obviously local variation in the content of law by jurisdiction. So the federal government has its own laws, the state governments have their own laws, each state has its own law. But even within jurisdictions that have their own law, there's an amazing amount of local variation. That's true among the circuits, which are all applying federal law. It's true even within circuits, within each district, and the federal district courts have their own rules. They'll have their own pattern jury instructions. They'll have their own way of conducting rules for lawyers to follow. And all of that, what your talk made me think about, is to some extent an artifact of geography and the extent to which the place where courts are located has been thought to justify them having their own set of rules unique to them. And I take it a thrust of your talk pushes towards a questioning of that assumption and towards uniformity more generally, which I know from experience is not something that always goes over very well with judges. And so I just wonder how you think about the relationship between uniformity and disuniformity in light of the observations that you're making.
Well, I think that's a very interesting question. You may have noticed at the beginning of the talk, I mentioned something that I feel very strongly, which is that parochial systems of justice, particularly in Europe, are very parochial. They were devised in particular countries, whether it's Slovakia or the Czech Republic or Italy or France or Poland, to deal with questions in those particular countries. And they all have very complex and prescriptive procedural laws, exactly what you're talking about. Just as we do, we have something called the Civil Procedure Rules introduced by Lord Wolfe in 1999, but in substantive terms, it's no different to what it replaced, which came from 1875. So nothing has really changed. The rules are very prescriptive. My idea is that the online space allows us to free ourselves from those prescriptive rules because there is a different and higher objective, namely the identification of the issue between the parties and the resolution of the issue. And if you are laying down prescriptive rules which actually prevent the speedy and cost-effective resolution of a dispute, then you are not giving access to justice. And our modern technology can free us from many of those constraints. And in the UK, we're at the moment considering the introduction of online rules, which would be at a much higher level of generality than the current prescriptive rules that you have and we have. And I think you're right. Once a uniform or more uniform set of high-level rules, which simply laid down the standard, was available in one country, it would quickly spread. And I just allow myself one more comment, because the UNCITRAL and the European Law Institute have actually already written a set of rules, a common set of European procedural rules that are at a high level. They ignore most of the prescriptive rules in European countries and in the UK, and they are intended to be applicable everywhere. And when I first heard about that project in 2013, I said that won't finish until 2050. It's never going to happen, but it's happened. And it's very worthwhile looking, not because perhaps it's the last word on the subject, but because it shows it can be done.
Richard, any thoughts on your part on that question?
On that particular question, nothing to add. Am I allowed to, David, do you give me permission to make another observation?
You do, I will. Maybe I'll ask the Chancellor this part, and then I'd love to have you make your observation, and we'll move to our next questioner. I wonder, Chancellor, will there be pressure? You described it, I think, quite well as thinking about what the uniform procedural rules that will be to get to the heart of the matter. But as law professors, we often talk about the interaction between procedure and substance, and that we also have different substantive laws in different jurisdictions around, and certainly in our country, that's a deep part. And so as people, the resistance to uniform procedure is often met by the idea that it's going to change the substance in some way, or push towards a more uniform substance in a way that seems much more controversial. And I wonder if you've thought about that particular kerfuffle.
Well, I don't agree, but I know it's an argument that is raised. And the worst example, perhaps, is when in Belgium they introduced something called the Belgium International Commercial Court as a result, really, of Brexit, because they thought they would be able to resolve their own international commercial disputes instead of coming to London. And the argument was fierce, because the Belgian lawyers says this is illegal because it doesn't follow the Belgian procedural code. And our law is in danger, our substantive law is in danger, if you don't arrive at your procedural resolution in the correct way. Now, I'm afraid I disagreed with that, and I disagree with what you're saying. Well, not what you're saying, but what people are putting forward. Because actually, the procedure has developed in order to allow the substantive issue to be resolved, whether it's one of law or fact. And by the way, 90% of our procedural laws and rules, if not 95, are aimed at resolving issues of fact fairly, not law, because legal issues really speak for themselves. We all have experience of having a case where you say to your fellow judges, if you're sitting in an appellate court, this is wonderful, this is just a wonderful point of law, we're going to really enjoy the day, or whatever it is, because there's no procedure, it's just a lovely point of law, whatever it might be. And that doesn't concern procedure. So it's a complete myth, I think, to think that changing the process will change the ultimate decision-making resolution of substantive law.
Thank you very much. Richard, did you want to say something before we go to our next question?
Yes, very briefly. It's an observation, but it relates to something Geoffrey was saying, that one of the past Master of the Rolls, Lord Dyson in England and Wales, once said that any system that's got a 2,000-page user manual has a problem, and he's referring to the rules of procedure for our civil courts. And some people talk about it, and I think it's very important, the simplification of rules, but I just wanted to add that there's also a trend for those who are building online dispute resolution platforms that you actually embed the rules within the system. And that's to say, for people who are not particularly knowledgeable, they do not, on many occasions, they don't need to know what the rules require. They simply need to follow the steps that are laid out for them. Now, clearly, we're not talking here about very large, complex disputes, but going back to my earlier theme of offering access to justice, if we really are going to make our civil courts far more widely available, not only do we need to reduce the complexity and quantity of the rules, but it seems to me we need, in a sense, to hide them as well by embedding them within the system. So it was simply an observation rather than a question.
Thank you very much, Richard. Our next questioner, again, it gives me great pleasure to introduce, and this may become a theme, but was also my student who has gone on to great glory and has gone on actually to succeed our dear friend, Chief Justice Gants, and is now herself the Chief Justice of the Massachusetts Supreme Judicial Court, and that's Justice Budd. And Justice Kim Budd, would you please unmute yourself and ask your question?
Hi, can everyone hear me?
Yes.
Great. Professor Wilkins, thank you so much for this opportunity to participate in this important and timely program. And I also wanted to just briefly thank Harold Coe for his remarks and his pictures of our chief, Ralph Gants. Ralph's untimely passing was devastating to the entire judiciary in Massachusetts. He was a mentor and friend to me, and although I will work very hard to be a worthy successor, I'm well aware that I have big shoes to fill. Now to my question. Sir Vos, I was fascinated to hear your thoughts about the future of the court system and dispute resolution generally. Obviously, we, like courts everywhere, have ramped up our use of technology to try to keep the wheels of justice turning during the pandemic. And as you pointed out, using technology is going to continue long after we can start to get together in large numbers in person. Harold Coe referenced Chief Gantz's concern about the fact that many pro se litigants do not have ready access to technology outside of perhaps a smartphone. And so I was wondering if you had any thoughts on how courts might think about using technology to facilitate access to justice for this category of litigants. What should we be thinking about as we prioritize allocating scarce resources?
Well, I think we think in England a lot about vulnerable litigants, and there are, of course, many. But it's another case where you have to make sure that those people are not disadvantaged in a justice system, but you don't create an entire justice system for those small percentage which are disadvantaged. You simply make sure that they have other means of accessing the system you create. And that's what we're doing. I mean, for example, there are a decreasing number, but still a large number of people who can only use paper, who don't even have a smartphone. And then there are others who don't have a computer, but they do have a smartphone. And actually a smartphone is pretty effective. I mean, I know that people of my age find it rather difficult to use a smartphone for the things that we use a computer for. But people in their teens and 20s don't find any difficulty with that at all, and can write a document on a smartphone faster than you can write it on a computer. So I don't think we should underestimate actually the use of smart technology. And I also think that it's just a question of dealing with the communities themselves. And you know, as somebody mentioned earlier, there's often a case of linguistic problems where you have multi-languages, people can't speak the common lingua franca, and they need a lot of help to get access to a justice system. I mean, we have in London a vast number of languages spoken by our population, and the justice system makes it accessible for all of them. But again, don't let the tail wag the dog. The fact that that makes it a problem does not inform how you create the best access to justice for the majority of businesses and individuals. And you have to think, as I say, holistically about all the types of dispute that you're resolving. It's no good just thinking of whether it's possession disputes or money claims or commercial disputes. You have to think of the many disputes that exist between individuals and the state, the many disputes that exist between families and family lawyers. I was on a seminar last night where a family lawyer said, well, all this is very interesting, but in family lawyers always have to operate face to face. Not so. Our family justice system has taken, like a duck to water, to remote hearings. So we shouldn't assume that anything, I think, about technology, because I take the view that the young people, there will be vulnerable people amongst the youth as well as the aged, but the young vulnerable people will be able to use and adopt technology and will find it actually more useful to make sure they're included. It's less likely to exclude them than it did in the past.
Well, that's actually a perfect segue to our next questioner, who is thinking a lot about technology, and I know Richard knows him well. And it also raises an issue that some of the questions that have been coming in, we've been monitoring in the Q&A function about things that are happening outside of either Europe or the US. You mentioned language, and we like to think of ourselves as two people divided by a common language in the old joke. But in Asia, there are lots of interesting experimentation going on here, and in Singapore in particular. And we are very lucky that Kenway Tan has agreed to join us. He is the head of innovation for the Singapore court system. And so, Kenway, would you please unmute yourself and ask?
Thank you. Thank you, Professor Wilkins, for calling on me, and good morning from Singapore. I look after transformation and innovation for the Singapore judiciary across the different levels of court, and we are seeking to implement a vision that was charted by our Chief Justice. Now, we are in full agreement that we should not replicate paper processes, and also that we should do a lot more to enhance access to justice so that people who cannot afford or may not even know about how to hire lawyers can seek legal remedies that they should have available to them. And we are also, as suggested very strongly by Richard, pushing ahead with asynchronous hearing capabilities and the little bits of technology to support this, so that lawyers can reply and take part in such hearings, on their smartphones. Although some have questioned whether this might not result in some unfortunate utterances by parties as they're traveling on the tube or traveling home or in the midst of an argument at home. The jury is in any case still out as to whether and how successful these various efforts would be for us here in Singapore. But we do know that the UK has embarked on a very ambitious reform program, and I wonder if it is possible for the Chancellor to share with us some thoughts as to how this program has been coming along, and whether or not there are some top takeaways that you may recommend to other jurisdictions, or conversely, are there certain experiments that, with the value of hindsight, you would suggest that perhaps need not be tried? Thank you very much.
It's a very interesting question. Thank you very much. The reform program in the UK has been a very large one. And of course, we have quite a large justice system, because in the US, for example, it's broken down into states, whereas we only have really one justice system in England and Wales. And therefore, the reform program has to be very ambitious. And I'm not going to pretend or suggest that it's a completely smooth ride from the beginning to the end without interruption. We still have, for example, to digitize the county court, which is the court that deals with the smaller court disputes. But actually, we have done really well. And we brought forward an online civil money claims, so you can bring a money claim under £10,000 online. We're about to start with small damages claims. They can be brought online. And we're going to then, well, we've already started with possession claims, with divorce claims, and with some social security claims. Disputes can be brought online. So it's a very big project, and the criminal justice system has also been digitized. So a lot has been done. With a big system, it's something that takes time. And one thing we've learned is that it's absolutely imperative that every part of the system you're creating talks to other parts. And not as easily said as done, because we're creating 50 what we call common components. For example, the component that whereby a court user pays a fee to the court, the component whereby the judge signs on to his or her computer every morning to find out the schedule, the scheduling and listing component. And there are 50 of them, you won't be surprised to hear, across the justice system. And if they don't talk to one another, then you're stymied in a most impossible way. And I won't pretend that that hasn't happened at some stages in the process. But we're on track now. And I think the most important thing is to make sure that you have at least a direction of travel in view when you begin. It's a little bit like what I was saying in my talk. I'm not pretending that one vision is the complete story. What I'm saying is we need a direction of travel towards a justice system which works for a society which operates with the technological changes that are now taking place. You know, I was brought up in the days of foolscap paper and Tipex, where if you had to change a document, you used something in a bottle that smelled terrible and made you feel ill. And that's a long time ago now, but I'm not going to be able to predict. Only Richard can predict what's going to happen in 20 years' time technologically. But all I can say is I must create a system which will work for people who are being born now and people who are born in the future, not just for old people like me who are going to fall off their perch before too long. And it's unfortunate that the leaders in our society are often old people who don't have a very forward-looking view, and they think that what's happened in the past is all jolly good. And I'm not saying what happened in the past is bad. I'm just saying I want to replicate it and make it accessible to people who are being born now.
Well, we certainly hope you don't fall off your post anytime soon. But Richard, would you maybe comment a little bit about what else you're seeing around the world? Because we have several participants from other countries around the world as well. And what at least innovative are you seeing?
Well, thanks very much. Geoffrey kind of said, I think it's being amusing that I could tell the future. One thing I can tell you is that the least likely future is that nothing will change. And yet that is the premise upon which many lawyers and courts base their strategy. What I can also say to you, and we can come back and discuss it in a decade's time, that it's likely that legal and court life will be dramatically altered by 2030 by technologies that haven't yet been invented. I see both of these things just to suggest to you, and it was what I was saying in my earlier talk about the new orthodoxy, that the panel, wonderful though it was very much assuming that the future is a variation on video hearings. And so that's why I'm fascinated by different kinds of developments around the world. When Geoffrey was talking about these various online processes, incidentally, he wasn't referring to video hearings. He was meaning the more the asynchronous type hearing for possession claims, damages claims, small claims, and so forth. What I mentioned earlier, but I just want to say a little bit about it because I think it's the best case study to look at in Canada, the Civil Resolution Tribunal. And although it's a tribunal and not a court, it's still a state-based public resolution system. And it is fascinating how it works, that it's designed not by lawyers for lawyers, but using a technique that's known as design thinking, very much user-centric, trying to develop a whole set of tools and techniques that non-lawyers can use without difficulty. No one's anti-lawyer in all of this. It's just that the current system is unaffordable to most. And so the first step or the first stage is what's known as a solution explorer. And it's a piece of diagnostic software that actually helps people understand what their legal position is. And this is very powerful. And it's designed for someone who has a reading age of 10. And this goes back to the point about the vulnerable and those who are perhaps not, if not computer literate, perhaps not fully familiar with or comfortable with legal language. This is quite the contrary with the Canadian system, which is designed for people to speak in a very plain English language. And if the solution, sometimes the solution explorer will, as it were, dissolve the problem rather than resolve it, but sometimes people will need additional help, and there's online facilities for negotiation, for facilitation, and the decisions that, or the outcomes of these processes actually can, through the tribunal online, can be given the authority essentially of a court order. Some cases do eventually reach some kind of adjudicator, the tribunal members or tribunal chairman or chairpeople. But almost none of these cases is ever conducted in person, and they're not virtual hearings either. Again, they're all done in the papers. So if you want to see a full case study of something that's been built from the ground up, you can see it there. There's similar developments in China, in Australia, in the United States too. William Gibson, the science fiction writer, once said the future has arrived, it's just not evenly distributed yet. And I think that's right. I think what we can look at is illustrations of bits and pieces of the future. If you aggregate these, it adds up to a very different system. I just want to urge people to think beyond, not to ignore, but to build on the success of video hearings rather than thinking this is the end game. What strikes me though, as never before, is that we have many academics, we've got many practitioners, many judges who are now very interested in seeing how they can push the boundaries. They're fascinated in the way in which we might embrace technology. And so it's early days. For me, still the asynchronous hearing and the extended courts are the most attractive ways ahead for high volume, low value cases. It remains to be seen how quickly they're taken up across the world. Geoffrey's absolutely right though, about not letting the tail wag the dog. Very often when you talk of these systems, people argue from hard cases. They take either very vulnerable people or very complex cases and wonder why a basic technological system doesn't fully meet their needs. I just wanted to close in saying that quite useful, I think, in the approach in the English reform program is something called assisted digital. And that's a way of meeting the needs of very vulnerable people. It's not saying we run a parallel manual system. It's saying that people who are vulnerable get assistance in using the digital system. And I think that's entirely appropriate. So what we need to do as a community globally is bring together, we try to do this to some extent, remote courts worldwide, try to bring together these kind of insights and developments so that we can all avoid duplicating effort and reinventing the wheel.
So we're going to talk about that in our last session, Richard, because it's such a fascinating project. But before we let Chancellor Vos go, who's been so incredibly generous with his time to be with us this afternoon or evening, I think, in your time. We've gotten several questions in the chat that actually go to something that was discussed in the advocates panel earlier in the day, and I'm not quite sure how much you had a chance to hear that. But it goes to another kind of hard case. And not so much hard case, perhaps, but another way of thinking about the courts, which is as a kind of ceremonial important place in which there's a certain kind of majesty, as Kathleen Sullivan talked about court proceedings, which is actually very valuable, she says, to the clients who come to the court. And it's also sometimes a source of a place for protest. So in our jurisdiction, you probably are happy you don't have this, although maybe you do. Whenever there's a Supreme Court hearing of a controversial case, there's a whole mob of people who come and stand out on the steps and protest. And that's become a very important symbol of how the law is operating. And so I wonder, as someone who's thinking about perhaps the most magisterial court system in the world, and certainly one with one of the longest traditions, how you think about that aspect when you think about these issues.
Well, I don't think you can teach us anything about dressing up. We're pretty good at that. And we've certainly had a magisterial court system, although I was surprised when I went to the Cour de Cassation in Paris to realize that their building, or certainly their courtroom, is more grand than anything we sport in the UK, with plenty of gold all around. But seriously, we do have people who demonstrate outside courts in the UK when there are important hearings being decided. And obviously that's a good venting point for tension, which shouldn't be discouraged. But again, I don't think we should tailor the system. I think you said it yourself. This is another hard case. I don't think we should tailor the system to particularly encourage or discourage that. I think the grandeur is something that older people value because it's something that has come to represent for them state justice. It's not necessarily the case that younger people value state justice in the same way, or rather that they see state justice in the same way. They may respect the judge just as much, but be quite happy to look at the judge on a screen. And I think one of the things that I said at the end of my talk is, under no circumstances must we compromise on the integrity of the judges, the integrity of the system, and the confidence that people have in that system. And when we do surveys in the UK, which we do very regularly as to what people think of the judiciary, I'm pleased to say that even amongst young people, we still come out very high on the level of confidence. People trust judges much more than they do many other kinds of people, not as much as doctors, but much more than politicians and other types of people. So I think the key to it is not just to go in for grandeur and dressing up or big courthouses, but to make sure that the process is sufficiently respected. And we are developing systems, we're developing programs that will instill into people the formality of the process, a respect for the process, but without it necessarily being in a big building with lots of wigs and gowns. You can actually have a very simple online process. If you do have to have a virtual hearing or a real hearing, we don't dress up anymore for civil cases in all the things that you recognize. We wear a simple gown like you do, and we're still just, I think, as well respected as we were. And I think it'll change. I think that the system will be respected without any of that. But you have to look again to the people that you're asking to respect the system. In the old days, people went to a lawyer if they wanted to buy a house and sat in a room with the lawyer for some hours discussing the purchase of a house. They don't do that anymore, but they still respect the lawyer and buy the house.
I think, David, there's terminological issue here to some extent. Our Chief Justice talks about the solemnity of the occasion, preserving that, which I like rather than the majesty. There's a question here, I think, about whether or not there is any intrinsic value in majesty. It goes a bit back to my thing that patients don't want doctors, they want health. I'm not sure court users want majesty. They want some kind of authoritative, respectful, serious outcome. We have to watch as lawyers, we don't confuse how we've always done things with the outcomes and the results that the community want of us. I think Geoffrey's point is so powerful with the next generation. What might seem majestic to our generation may seem much the reverse. And so insofar as, and I think the rule of law is at stake here, that we want our court systems to be regularly affirm the authority and the bindingness of law by being relevant and solving a wide range of problems, it's important to me that that's not simply perpetuating our past practices or automating our past practices, but that we are designing a system, again, I think using design thinking techniques that meets the needs of the next generation and not the past generation. Geoffrey's point is also right, that the issue is that many of the policymakers and the decision makers are of a later generation than those who are going to be the users.
Well, I can't think of a better way to end on than with the hope of having an incoming master of the rolls who takes that kind of thinking to thinking about one of the most important court systems of the world. Chancellor Vos, we cannot thank you enough for taking the time to be with us here. I know how busy your schedule is, but I know that it was immensely valuable for everyone, including myself, to have the chance to hear your thinking about this. And I hope you won't mind if through Richard or others, we check in and see how things are going. And if there's any way in which we at the Center on the Legal Profession or Harvard Law School more generally, or any of the listeners on this call can help, we certainly would love to do so.